Getting called to the CCMA can be quite scary and intimidating. Whether you're employer or employee, you need to know the process when it comes to the CCMA. So the CCMA has two different processes that they follow: conciliation and arbitration. The first step is normally conciliation. Conciliation is an informal process where the parties would sit with the commissioner and they would see, the commissioner will facilitate the process and see how he can assist the parties to reach a settlement. More often than not, a settlement is reached. But in many cases where settlement can't be reached, the case would go over to arbitration. I won't go into the technical points of getting to arbitration, but at arbitration, this is where the parties get an opportunity to present their case, call witnesses, and present documentation. It's very important to be prepared for this, to have bundles, and this is where legal representation is also allowed for both parties. Attorneys can represent companies as well as employees in some instances and should normally bring an application for legal representation at the CCMA when it comes to arbitration. After the arbitration is concluded, the commissioner will give a binding decision. Remember, the CCMA is not a court, but it's still serious. You need to be prepared. You need to have your documentation and know your facts. And also, it's important to understand your rights. So if you ever get a CCMA notice, don't panic, because with the right representation, you will know exactly what to expect. Experts know what to look for, how to structure cross-examination, and which questions to ask to protect your rights. Having someone that has mastered these skills can make the world of a difference when it comes to the CCMA and presenting your case. So you won't have to stress, it will be smooth and with a fair resolution.